The Texas justice system is messy, so let's break it down. You're listening to So You Got Arrested, the podcast that tells you what really happens after an arrest. Hosted by BRCK criminal defense attorneys, we talk to the people who've lived it, worked in it, and been shaped by it. Whether you're facing charges or just want to understand your rights, your options, and the smart moves that could change everything, we've got your back.
Scott, one of the things that I wanted to talk about was probation, and specifically what happens when you have a violation of probation. You know, it's otherwise known as a motion to revoke or a motion to adjudicate. If you would just kind of explain, what is probation?
Okay, so probation, we use that term for two different things. One, you can either be on deferred adjudication, meaning that if you complete it successfully, the case will show as dismissed and you can honestly say there's not a conviction, or you're on regular probation, which means you've already been convicted and it limits what the punishment can be.
And when you're on these probations, whether it's a deferred adjudication or a regular, sometimes referred to as strict probation, you have all these conditions that you have to follow.
Right.
And what happens is, you know, the idea of probation is it's also called community supervision because you're allowed to remain in the community. You're not being incarcerated. You're not being locked up. You're allowed to remain in the community so long as you follow certain conditions and you're being supervised. But when you violate one of those conditions, it triggers a process.
Right. And so sometimes, a lot of times when you violate, your probation officer may not file a motion to revoke. He may just say you're doing regular P tests and you tested positive for marijuana. Mm-hmm. He may say, when's the last time you smoked? Oh, a couple weeks ago. And because marijuana stays in your system for 30 days.
Right.
Okay. And so they may not initially file a motion to revoke probation. But if the problem continues, eventually they're going to file a motion. The DA has to sign it. And if the DA and judge both sign that violation of probation, a warrant goes out for your arrest. Mm-hmm. Usually that warrant comes with no bond. So your attorney has to go get a bond set. Now, you're not entitled to a bond if you're on regular probation, right, straight probation.
Because you've already been convicted.
Correct. But usually we can get you a bond anyway. Mm-hmm. At least our office can. I don't know if everybody can. Right. But on deferred, you're entitled to a bond.
Right. Because you're not convicted. Correct. The case is still technically unadjudicated.
But in Bexar County, a lot of the times, even though you're on deferred, initially that motion to revoke comes out with remand without bond. Mm-hmm. And the attorney has to go get the judge to set a bond. But the judge will set a bond because they have to.
Let me ask you this, because I know in the jurisdiction where, you know, I practiced for a long time, south of Bexar County, prior to that motion to revoke being issued, they would have like an administrative hearing in office with probation, where maybe they would tell the probationer, hey, you keep testing positive for meth or whatever it is, we would like you to attend rehab. And then if the probationer says, no, I'm not going to do that, then it triggers the motion to revoke. Do they have a process like that in Bexar County?
Yeah, they do. It's just haphazard depending on which judge. Every judge does it a little bit differently. Okay. And of course, each probation officer handles it a little differently. So what I always tell my clients when they're on probation, some probation officers are pleasant. Some probation officers are jerks.
It's doesn't like matter. Else.
You better get along well with your probation officer.
Right.
So there's a possibility that they're going to just add conditions without putting out the warrant I talked about. Mm-hmm.
So the conditions might be go to rehab, or, you know, initially maybe it's just like seek outpatient treatment. Mm-hmm. And then if you don't go, or they may say you're going to have to come in instead of monthly UAs, you're going to have to come in every week. Right.
And we have people who don't submit the urine sample because it's like $15 every time you do a UA, mm-hmm. and they don't go submit because they don't have the $15. Wow. And they won't let them do it, by the way, without the money.
Right.
And so we get people, and you get the violation shows violated condition number 2, which is using substance, but they didn't really violate it. There's not a positive UA. It shows failed to submit on the violations.
Right.
So it's kind of chicken shit in a way, but this is the reality of the situation.
Yeah. And you know, there's so many things that you raise an interesting point, because when people are on probation, a lot of times what happens is they may have a minor violation, mm-hmm. Like Scott mentioned, where maybe they didn't have the money to pay for the UA. And so they just, you know, whatever, or maybe they didn't pay their fine, you know, but because of that minor violation, they quit reporting.
Exactly.
And can you explain what happens at that point?
So I think it's important for all attorneys to tell this to their clients, because what happened, you and I, we've seen it 100 times. They're not paying their supervisory fee. When you go into probation, you have to pay like $40 to $60 supervisory fee every month, and you have to pay your fine and court costs. Well, they don't have any money because they can't get a job because they had a criminal case. Right. And so they're reporting, they're doing what they're supposed to do, but the probation officer keeps saying, yeah, I got to start paying money. If you don't start paying money, I'm going to revoke you. And then next thing you know, they stop showing up. No one will ever revoke your probation because you haven't paid money. We don't have debtor's prison here in the United States.
In fact, it's a defense.
Yes.
If you're indigent, they cannot hold the fact that you haven't paid your fines and your fees against you during a probation revocation proceeding.
But once you get afraid because they told you they're going to issue a warrant because you're behind on fees and you stop reporting, they will revoke your probation.
That is perhaps the most serious violation.
Yeah. The most serious one is to commit a new crime.
Sure. But failure to report is up there.
Because it's one of the simplest ones to do. If you're not going to do that one, you probably aren't going to go to rehab either or anything like that.
So we were talking about, you mentioned, the two different types of probation. You can be on this deferred adjudication or you can be on regular probation. One of the things that's interesting is that when you're deferred adjudication, I've always explained it to clients as it's all or nothing, right? Because on deferred adjudication, if you successfully complete it, that case is dismissed. And you can say, hey, I've never been convicted of an offense. But if you violate it, and the violation's serious enough, and the judge goes ahead and finds the violation to be true and adjudicates you, you are now subject to the entire range of punishment for that offense, up to the maximum amount of punishment. Right. But it might be different on straight probation, right?
Right. So, and let's talk about it in terms of felonies.
Okay.
Because there's not too much difference between misdemeanor, regular. Sure. But so if I have a third degree drug case, okay, and so I have regular probation, 4 years, suspended and probated for 4 years. Mm-hmm. If I've violated my probation, the most the judge can give me is 4 years.
Right. Because on regular probation, you're actually sentenced to time.
Right.
But then the judge suspends the sentence and puts you on probation.
And what we're used to is usually the underlying sentence, the first number, is kind of the same as the time on probation, but it doesn't have to be.
Right.
You could be sometimes. What I used to do as a prosecutor, I'd be like, I hated when prosecutors wanted to put you on 10 years probation. That's the maximum term of probation.
Right.
The probation office isn't equipped to have people on that long.
Right. So it's the minimum is 2 years. The maximum is 10 years. Right.
Right. And so, give me 5 years probation. And then they'd say, well, okay, but I want the biggest underlying sentence, 10 years. And if the defense attorney said to me, well, I don't want him to have a high underlying sentence. I'm like, you saying he's not going to do well on probation? Is that what you're telling me? Because you should want and so I kind of want a high underlying sentence.
Sure.
But most times in Bexar County, in smaller jurisdictions, it's different. Most times in Bexar County, the judges like the underlying sentence to be the same as the length of probation.
Oh, that's interesting. I didn't.
Yeah, they just like it like that because it just confuses people. I don't know why.
Yeah.
But on deferred, so I saw somebody yesterday when I was in court get put on deferred for a first degree felony, and that scares the piss out of me. I never like to put my client on deferred because a first degree felony is punishable by 5 to 99. If you mess up your probation, you can be revoked and get 99 years.
Right. Right.
So that makes me nervous.
Right. Whereas if they were on straight probation,
right,
the most you could get is 10 years because the way it works here in the state of Texas is for regular probation, you're not eligible if you have more than a 10-year sentence. So keep in mind, regular probation, the judge is actually sentencing you to time. But if they sentence you to anything more than 10 years, you're ineligible. So on regular probation, the most amount of time you could get on a violation is the underlying sentence. And the biggest number that could be is 10 years.
Right. Now the other caveat to all that is the reason some of these guys are getting deferred adjudication for first degree.
They're being set up.
No, but they can't get regular probation.
No, I get that. Yeah. But I've literally had prosecutors say to each other, I'm going to offer his guy deferred because I know his guy's going to screw it up and it's easier for us to get him into prison.
Get them, and we can get a high sentence.
That's it.
But so if you have an aggravated assault with a deadly weapon, you can only get deferred adjudication. There's certain crimes that we've discussed in other podcasts.
Sex offenses.
Yeah, offenses, violent crimes, anything involving a weapon where I know it sounds counterintuitive, but the law doesn't let you get regular probation. You can only get deferred adjudication.
Right.
Okay.
Right.
And so that's why you're stuck if you have an aggravated assault, that's 2 to 20. So you can't get regular probation because if you're convicted, you have to go to prison.
Right.
So you can get 4 years, 5 years, 6 years deferred adjudication. But if you mess it up, you're looking at 2 to 20. Mm-hmm. Now, we are fortunate in Bexar County that there's not many judges who are maxing people out on revocations. Mm-hmm. But if you get into the Hill Country or your county, mm-hmm. there are judges that if you mess up that deferred, you're looking at the max.
Right. Right. That's exactly right.
Is that like common in like Wilson or Atascosa, or what's going on with that?
No, the judges are usually pretty good in that they're not automatically going to max you out. One of the things that I wanted to ask you about is on a revocation of probation. I don't know the policy in Bexar County. Like I know, for example, south of Bexar County in what we call the 81st, Wilson County, Karnes County, Atascosa, you can have a plea bargain on a motion to revoke, meaning you've revoked your probation. Now they're trying to figure out what to do. Maybe the violation's clear, right? Maybe since then you've been convicted of a new offense. Maybe you didn't report for a year. You what we call absconded. Now you're back in court. We're trying to decide how to fix this. And you can actually negotiate an outcome with the prosecution and go to the judge and say, Judge, we have this agreement either on a sentence or that this guy's going to go to rehab or whatever it is. I know some judges don't allow that. Some judges, you're on their probation and they're going to decide what happens.
So as we sit now, all the felony judges in Bexar County will go along with the plea agreement. Okay. But they will tell you ahead of time, they don't have to. In other words, unlike a plea, where if the judge doesn't go along with it, you can withdraw your plea. Mm-hmm. On an MTR, once you plead true and you're pleading true to getting revoked and getting 4 years prison, if the judge decides to give you 8, you're stuck like Chuck.
You can't withdraw your plea and say, well, that violated the plea bargain agreement.
Right. No, and so we don't have that ability. But in Bexar County, all the judges currently right now have been honoring those types of agreements.
Okay.
We used to have a couple judges in district court who would tell you right up front, you can't negotiate. You're either pleading true or it's set for a contested, because I don't care what the state says. This is my probation.
And that was my experience. My experience was that, hey, they don't allow plea bargains here. You're just at the mercy of whatever the judge.
No, those judges aren't around anymore. Okay. The couple who did that aren't doing that anymore. But it is a more, you have to go in eyes wide open.
Right.
And what we call there's two types of violations: technical violations
and non-technical,
or new number ones.
Yeah.
And they're called number ones because the first condition of probation is not to commit new crimes. So if you commit a new crime, they don't have to. You're not entitled to a jury trial on that issue.
I just had that play out.
Yeah. I saw that.
And so, it is different because when you get placed on probation, you have a list of like 20 different rules that you have to follow, right? And you shouldn't violate any of the rules,
right?
But there are some violations that are much more serious than others. And in my experience, the most serious violations are going to be violations of either one, you committed a new offense, right? That's very serious. Now, I always get this question, well, what if I get a speeding ticket?
Yeah, no big deal.
That's not going to be a big deal. What I always tell people is, look, you need to be concerned about something that you're getting arrested for. That's going to be a problem for your probation. In my experience, the second most serious type of violation is failure to report. Mm-hmm. Now, if you have a month where maybe you didn't report because you were sick or you didn't have a ride, usually that's not a huge issue. But once you fail to report and you become an absconder where you haven't reported in 6 months, usually the end result of that is prison, unless you have a very good reason why you haven't been reporting for 6 months. And then the other big one that I see is if you're consistently testing positive for drugs. Yeah. Usually they'll give you some kind of rehabilitation first. That is kind of a progressive sanction. They start off with some rehab, but if you just keep testing positive, despite rehabilitation, despite inpatient treatment, at some point they will revoke your probation and send you away. But then you have these other conditions that you have to follow where you shouldn't violate them, but if you do, it's not as likely that you're going to end up going to prison for it,
Like you're not supposed to associate with other felons. So, but
Right.
we have a lot of, like somebody I had just now, I just got her continued and she went home, but her boyfriend's also on probation.
Mm-hmm.
Okay. But there's they're okay. The probation knows that these two are together. But in theory, living with another felon could be a violation.
Right.
But there's one other thing I got to say about conditions. So for instance, if you're on for domestic violence probation and you pick up a violation, the first thing all the judges in Bexar County ask is, did you complete the batterer's intervention course?
Right.
And if you completed it, you get a lot of leeway on that motion to revoke. And I've heard judges like, oh, wow, they completed that.
Yeah, it's called the BIP.
Yeah, call it the BIP. And so you are in good shape on that motion to revoke if you've done that. That's the first thing I ask my clients. Did you do the BIP? And if they've done it, we are walking into court knowing at least my guy did what the judge cares so much about. And the reason they care so much about it is because we know from statistics that people are less likely to reoffend once they've completed the BIP.
Well, so I want to talk about the process and the procedure of the actual motion to revoke hearing, but we'll do that after the break.
Okay. We're just running late today.
The attorneys at BRCK Criminal Defense have helped over 5,000 clients move on with their lives. When an arrest or accusation turns your life upside down, we have the knowledge, experience, and integrity to get your life back on track. Traditional legal ethics, modern legal tactics, the best defense possible to get you through the criminal justice system. Search BRCK Criminal Defense to see our reviews and find out why so many of our clients have trusted us to fight for them. BRCK Criminal Defense, helping our clients move on with their lives.
So there's a lot of misunderstandings when it comes to the actual hearing for the motion to revoke. So this is a situation where they say you violated your probation, you can't get it resolved with the prosecution, and now we're just putting it in the hands of the judge, right? So you're entitled to a hearing.
Yeah.
And do you kind of want to talk through, you know, what's involved in the hearing?
So what I try to tell my clients is the judge is going to want some type of punishment for violating it. So if I'm going to be successful in getting you continued on probation, they're probably going to want like a 30-day sanction or a 60-day sanction. So sometimes it's better not to bond out on your motion to revoke.
Build up some time. That time credited.
But every judge is different, and every judge cares about different things. Okay, so I tell you this, we have some very empathetic judges in Bexar County that if you have problems with your life and you're able to successfully say, here's why I stopped reporting, judge, because I knew I wasn't able to pay, and the judge will give them the same lecture I do. Well, if you didn't pay, I wouldn't have revoked you. You shouldn't have stopped showing up.
That's right.
But so what I have to find out from my client is, I'm not just going to stand up there and say, Judge, please continue my client. I need to know why.
What's going on? So back when I used to do a lot of court-appointed work, I would have clients who were homeless.
Yeah.
And they were on probation and they weren't reporting, but I mean, they had no transportation. They had no place to live. And so, you know,
we are so blessed in this county, in your jurisdiction and my jurisdiction. We have judges who are pretty kind. I like that they're not just like throw everybody away.
They'll take the individual circumstances into consideration. But when you're having one of these hearings and they're trying to take away your probation, you do have rights. I mean, you don't have to go along with what the state's recommending. You can have what we call a contested hearing. And that contested hearing is like a miniature trial, but it's not really a trial because your rights are different. Okay. So first of all, the burden of proof is different on a motion to revoke.
It's just by a preponderance.
Okay. So do you want to explain what that is? Or
don't even know if I can adequately explain preponderance. So it's just more likely than not that you violated.
Right. So if you go to trial on a new case, that the burden of proof is proof beyond a reasonable doubt, meaning the prosecution has to put on so much evidence that jury or that judge is convinced beyond a reasonable doubt you committed that offense. But in a motion to revoke, preponderance of the evidence, we just kind of, I call it the 51% test.
So that's the hard part about a contested hearing. A lot of times we plead true with an explanation because, like, if they didn't report from March of 2025 until they were arrested in November of 2025, I'm not sure they're going to have trouble proving that. All they do is they bring the probation officer and says, the last time I saw this guy in my office is in March of 2025. I'm like, and do you see that guy in the courtroom today? Yeah, he's that guy over there. Okay. And so, like, I've never had a client try to tell me, well, I went, and I don't know why they're saying that.
Right.
They'll say like, no, I was afraid and I didn't go. So sometimes we plead true, but we don't want to go along with what the prosecutor wants.
Sure.
So we call it pleading true with an explanation.
That's right.
We're not going to agree to revocation. You, prosecutor, ask for whatever you're going to ask for.
Right.
We're going to plead true to it. But there's also a lot of times you have multiple violations. So you might have didn't report, didn't do a class, did some of your community service. So we may plead true to certain violations and not true to others. We may plead true to all the technicals and not true to the new offense.
Well, and one of the things that clients are surprised to find out sometimes when we have these motion to revoke hearings is that you don't get a jury.
No.
It's solely in the hands of the judge.
Yep. So
it's people go into these things thinking it's like you get a jury trial and you get all of these. According to the Texas courts and according to Texas law, a motion to revoke hearing is more of an administrative process than it is just a brand new criminal proceeding.
Right. And we also get, and we don't get this on people that we've put on probation because we're good at explaining it. But you get that you've had that client who says, I shouldn't have taken the plea to begin with, and I want to argue about you shouldn't be on probation, and you're specifically not allowed to do that.
Does the judge know that I didn't do it?
Yeah.
And it's like, well, you're already on probation.
Yeah, we're not going to argue that.
That's right.
Because the plea paperwork you sign says, if you violate the probation, you're only entitled to a hearing on the sole issue of whether you violate the probation. You cannot go back and argue that you didn't commit the crime that you were put on probation for.
Right.
And there's a lot of people who don't get that.
Right. And so the motion to revoke probation in that hearing, like Scott was mentioning, can oftentimes be a much easier proceeding for the prosecutors than, them proving a whole new case in the middle of a jury trial, right?
Right.
And so I had a case recently where my client was alleged to have committed 2 new offenses. And so they were trying to revoke his probation, and those were his only violations. And, they were going to try to prove that these offenses occurred, but it's a different standard than a prosecutor trying to prove it at a jury trial. And so it makes it much more difficult to defend.
Yeah. So this is an interesting story when there was another judge who's no longer sitting on the bench in the 144th, not Susan Reed after that, who he was on probation for some kind of second degree drug case. We went to trial on
the judge was on probation?
No. As a prosecutor, I was prosecuting this guy for a sex crime.
Okay.
But he was already on probation for a drug case. He was found not guilty of the sex case, but the judge still revoked his probation.
Used the sex case to revoke his probation
because it's a lower standard of proof.
Oh, wow.
Yes.
Yeah.
That probably would take us like 20 minutes to explain all that. But because you could be found not guilty of a new crime, but since there's a lower burden of proof, the judge could still make a determination that he thinks you were guilty of it and revoke your probation based on it.
The example that I give to kind of shed some light on this is think about the O.J. Simpson trial.
Oh, yeah.
The O.J. Simpson, criminal trial, O.J. Simpson is ultimately acquitted of murder, of Ron Goldman. But then the Goldman family sues O.J. Simpson in civil court, and he's found liable for the death of Ron Goldman in the civil suit. The difference being that in that criminal trial, the burden of proof on the state, on Marcia Clark, was proof beyond a reasonable doubt. And in that civil suit, the burden of proof was preponderance of the evidence.
Which is the same burden for a motion to revoke.
That's exactly right. So that's how O.J. Simpson could be acquitted of the criminal act, but found, legally responsible for the civil act of wrongful death. Yeah. It's the same kind of thing that applies in a motion to revoke hearing, and people get frustrated with it, but that's law.
Right. So in the old days, some judges, if you had a new crime, they wouldn't let the prosecutor put it on in a motion to revoke. He'd say, no, you're entitled to, we're going to try the new number one.
Right.
And then we'll see what happens with the motion to revoke afterwards. But those days have gone.
Well, there was a change in the law. So it used to be the case that if a prosecutor tried to prove the new offense during a motion to revoke and you won, then that kept the state from trying that new number one. It was a defensive thing called collateral estoppel, but then they changed the law that said that no longer applies. So I think nowadays you're more likely to see a prosecutor to try to prove that new offense
Right.
during a motion to revoke than, maybe you would be in the past.
And so a lot of times what we see here is somebody's on probation in Bexar County or Wilson County,
Mhm.
but they picked up a new crime in Uvalde County. say.
Right.
So then the question becomes, is the prosecutor going to go to the effort of getting the police officers here from Uvalde County? Sometimes yes, sometimes no.
Right.
But these are things the difficult things that we're trying to navigate as your defense attorneys, trying to see it's put up or shut up
Right.
kind of thing.
That's exactly right.
But you could, but if you're calling their bluff and saying, "Go, we want you to prove it," then it's too late once you're showing up on the motion to revoke and they got all the officers sitting in the courtroom.
That's right.
Now they're not going to negotiate with you.
That's the thing is when you're you have this process of a plea bargain where the idea behind a plea bargain is you're getting something less than you otherwise might in exchange for you accepting responsibility and the state not having to prepare their case. But a lot of times once the state has prepared their case, that plea bargain's out the window,
right?
Because they've already prepared, they're ready to go, their witnesses are there. And
so when you walk in with your client hoping that they weren't going to be ready for that contested MTR and you see 3 police officers, that's the oh shit moment you have with you and your client.
Right. Yeah. And in my 20 years, I've been there a couple of times.
Yeah.
So another interesting thing that people need to know about the process for a motion to revoke is you'll have what's called a violation report. Mm-hmm. And that's a list of all of your violations. Okay. One of the things that people need to be aware of and look out for is if you plead true to all the violations, let's say that one of the violations is a brand new offense that's still pending. Your pleading true to that violation can then be used against you later on in another proceeding. So what's important is that people need to get their attorneys, and this is something that we're always cognizant of, that if our client wants to plead true on a motion to revoke, you plead them true to something that's not going to affect that case.
Right.
You plead them true to maybe one of those technical violations or maybe a dirty UA.
And you also can, so say I had this week, the new violation was an aggravated assault and he's on for deadly conduct.
Mm-hmm.
Okay. But so you can ask, we'll plead true to the new crime, but not aggravated assault. We'll plead true to the lesser of assault.
Oh, okay.
Okay. And that's an unusual way to go about it.
Right.
Okay, it's thinking outside the box.
But that saves your client from
right. Because my client's not going to deny that he got into it with this person, but the whole like baseball bat part of it,
sure.
we're not going to admit to the aggravated assault part.
Right.
Right. And so then whatever happens there, we'll plead through that to that lesser. And sometimes the smart prosecutors they don't have to prove. So if somebody's arrested for DWI when they're on a second degree drug case, they don't actually have to allege the DWI. They can just allege they used alcohol.
The drinking. I've had that happen.
Yes.
So I've had cases in the past where the new violation is a DWI. And so I'm geared up, ready to defend that. But the state has a breath test or a blood draw showing alcohol in my client's system. The alcohol in their system is in and of itself a violation.
Right.
They don't have to show that he was operating a motor vehicle on a public roadway while, intoxicated.
Or even argue about extrapolation facts or anything like that.
That's it. Yeah. Right.
So smart prosecutors will allege less than what they really have, knowing that they're going to have you one way or the other.
Right. So at the conclusion, so let's say they have this motion to revoke hearing and a client is maybe on that deferred adjudication where they're not convicted yet. And the judge says, okay, I find that you violated your deferred adjudication. What options does the judge have?
So let's assume it's not one of those types of crimes that you can't get regular probation for.
Right.
Okay. And if that's the case, then the judge can decide you violated your probation, revoke your deferred adjudication, but then put you on regular probation.
Right.
Okay. Or as we've said before, they can give you anything in the whole range of punishment.
Right.
Or they can say, I'm going to find you violated the probation, but I'm not going to revoke your probation, but I'm going to give you 90 days. The judge can give you up to 180 days jail sanction as a condition of probation. Mm-hmm. So they may give you, I'm going to have you've been in jail 30 days. You're going to sit another 60, and I'm going to put you back on probation. But let me tell you, if you're back here in front of me again, you're going to get the max.
That's right.
Right. So they're really not supposed to say that, because then I might argue later on down the line.
They've already prejudged.
They prejudged. And most of them are clever enough not to do that.
Right. So the judge does have a variety of options. If you're on probation, follow the rules of probation. But if you find that you've picked up a violation, don't hesitate to give us a call at BRCK Criminal Defense, 210-874-5080. Scott Simpson, Steve Barrera from BRCK Criminal Defense. Thank you for listening.
Thanks for listening to So You Got Arrested. If you found this podcast helpful, share it with someone who needs to hear it. For more legal insights and real talk from the front lines of the Texas justice system, follow us and subscribe. And remember, BRCK Criminal Defense has your back. For more information, visit us at brckdefense.com.